A company's competitor actually did not copy the logo, did not copy the brand name, but still Delhi High Court gave an injunction that this product should not be used. Do you know why? Because they did not copy the brand name and logo, but they copied the bottle shape, color, the appearance and feel of it. This is actually a real case which happened in the month of January 2026 between Emami's Navratna oil versus Dabur Cool King oil. If you are a business owner and you are going to copy another business idea, then your company is not under trouble. But as a brand owner, if you are going to copy the packaging of your competitor, then you are into a big trouble. In this video, I am going to tell you about how Dabur's Cool King oil was launched so big, but within few months they had to shut down because they copied the trade dress. What is trade dress and how you can protect it under trademark, I am going to explain to you in this video. Myself Rohini, your corporate lawyer from Leintelligensis Private Limited. Now let's see the background of this case of Navratna oil versus Dabur Cool King oil. In India, there is a cooling hair oil category in that Navratna oil has been a leader for so many years. And recently, last year, Dabur wanted to launch their own brand in this category and they called it Cool King oil. But here is where the problem actually begins. Dabur did not copy the logo or brand name of Navratna oil, but it actually copied something else which caused a confusion in the customer. And this customer confusion made the Emami's Navratna oil to file a case against Dabur in Delhi High Court. Now, the court made an observation between both the products, that is Navratna oil as well as the Dabur Cool King oil. When they saw it, as a normal customer, they could see that the name and logo were different, but looking into the product, the court confirmed that both had the same color of red and both the product had the same shape. And the third thing is almost the same type of images were used in the bottles. But the fourth observation is the most important one. Whenever a customer is walking into a supermarket and when he sees both the products and he is not able to identify which one is the original, then this is a clear case of trademark infringement. Trademark infringement is nothing but the original product has been copied by a competitor and the competitor is trying to steal the goodwill of the original product. Observing this, the court gave an injunction to Dabur stating that they should immediately stop using this Cool King oil in the cooling oil category. Now seeing the important legal concept behind the case. The concept is trade dress. Trade dress is nothing but the product's outer cover, outer design. The outer appearance of a product is generally considered as a trade dress. For example, you will be able to see the Coca-Cola bottle as well as Pepsi bottle. Looking at the shape itself, you will be able to identify the product because the brand identity is created with the bottle shape, the bottle color. In the same way, Navratna oil has created an identity with the red color and with a particular shape for so many years. Now this brand identity, when some competitor is going to copy, the customer will lead to a confusion. This confusion is actually the risk of copying. That is where the legal case comes into place. Now, when you say trade dress, whether it can be registered under trademark, yes, a trademark not only protects the logo, brand name and tagline, actually it also protects the label, the outer cover of the product, the outer design of a product. Whatever is a brand identity, trademark covers and protects the whole of your brand identity. In the same way, Navratna oil has protected their brand identity with color, shape, feel and images by protecting their label under the trademark registration. Not only Navratna oil, there are many other cases which was filed in India for protecting the brand identity. The first case is Apple versus Samsung. Samsung actually tried to copy the iPhone design and tried to launch a product. Immediately, Apple filed a case stating that our product has a specific design and that design is our brand identity, so they protected their brand identity under trade dress. The second case is Cadbury versus Lotte. The Lotte company wanted to actually copy the Cadbury's brand identity of purple color. They tried to launch their product in the purple color and they wanted to create a feel of Cadbury in their product. immediately Cadbury filed a case stating that they are copying our trade dress and they stopped Lotte from using that purple color. Now recently in the year of 2024 and 25, the Red Bull company filed a case against all the companies who were their competitors' energy drink to stop using the different versions of Bull that they were using in their brand. Now all these cases, we can see that they were not trying to copy the name or the logo, they were trying to copy the look and feel which the other company was already having. Before knowing the important legal concept, if you are a business owner already running your business or newly starting your business, we have an exclusive WhatsApp business community. In that community on a daily basis, we are sharing the information about developing your business or starting your new business. If you want to be a part of it, in the description we have given the link. Kindly click on the link and join now today. Now here comes the 3 important business lessons for all the business brand owners out there. Whenever you're going to launch a product, you might want to immediately grow, and in order to grow immediately, you might try to copy your competitors. But if you're going to copy your competitor's product, then what happens is you lose your originality. On the second hand, you will end up getting a legal problem. Now the second business lesson is, whenever you're going to end up in the legal problems like this, you might have invested a lot of amount in building the product, in promoting the product, and you will end up getting a huge loss. Now the third business lesson is, if you are going to have your original brand with your original creativity created, then in that case, your business can sustain for a long period of time and it can grow to a global level. Now coming back to the case of Navratna oil versus Dabur Cool King oil, Dabur has to suffer a huge loss because they had to stop using the product. They have promoted the product all over India. This is a huge loss for them. Secondly, if suppose they have launched a new original product in the same cooling oil category, they might have also become the number 2 in that category, but now they have lost the credibility of their own brand. Now here, Dabur actually did not copy the logo or the brand name. They tried to copy the memory of the Navratna oil in the customer's brain. That is where the whole problem is. Try to create your own originality in your customer's brain, otherwise you will lose the trust in the long run. In the same way, recently there was also another case which was filed between Sunfeast Wowzers versus Britannia Cheese Dip Biscuits. We will see about this case in the next video. If you want to protect your trade identity or brand identity under the trademark registration, then in that case call to this number and get your consultation today. Myself Rohini, your corporate lawyer from Leintelligensis Private Limited.